Honorable Mr. Justice Dipankar Datta, Honorable Law Minister, who brings the fragrance of my home state, although I always tell him that my hometown Jodhpur Safa is a strong competitor, if not ahead, of the Bikaner Safa, which he has popularized. Attorney General for India, Solicitor General, the benefactor of this great organization, Mr. Naveen Jindal, an old friend from the days of the eccentric Naveen Jindal, for whom I argued the right to fly the flag case. And as I always say, you need eccentrics like him to advance the law. Of course, the over-dynamic Vice Chancellor, you're always out of breath keeping pace with this man, Rajkumar. And this is another example of constantly ideating new things, new schemes, new programs. And you can see the growth chart of Jindal in such a short span. Friends, the danger of being a liked and a frequently invited guest speaker at Jindal, sometimes I missed it. It's a great privilege, of course, but the danger is that today's topic is virtually identical to what was discussed in this very room, with the fortunately only three common people, two of whom are here. Justice Suryakant is not here, me and the Attorney General, a few weeks ago. So, being the economizer of time that I sometimes am, I made a quick check around the room and I find that most people present today are not common. So I will take the liberty of repeating myself, because I can suffer the bored look of the Attorney General. But friends, much of what we are talking about today on artificial intelligence and the law shall be the reality maybe as early as 2030, but certainly 2040. People like me, if we are around then, are hardly going to become those special kind of horses who can learn new tricks in our old age. We are still going to call you for a conference at odd times, pore laboriously over marked photocopies of case law, and shout at you for not giving us a properly paginated brief. We will hunt for a good fountain pen. Two people in this room share a major vice for broad and thick-lipped fountain pens. The other one I will not name. And then painstakingly make notes in the back of some used paper and shout at our law clerks that the bulky file containing our notes is fraying and our old notes are either missing or torn at the edges. In the longer conferences with my spectacles drooping over my wrinkled skin in 2040, I am going to reminisce about the good old days where you could thumb a hard used SCC volume and use a pencil to underline its relevant parts. Well, sitting across the table from me on that 2040 evening, a bemused junior, one of those under 25 people who according to me should be the only category of speakers invited by Jindal and Raj today. We are all well above that age bar. That bemused junior would whisper to her 26-year-old colleague about the idiosyncrasies of this old senior counsel, whom the innovations in litigation seem to have passed by. This 26-year-old would then say, "Sir, if I might interrupt, why don't you use robotic process automation, RPA, in your office? We have used it for many years." Her third colleague, a wiser 30-year-old man, would chip in with the suggestion that as a senior counsel going to a new high court for an outstation matter, one of my chamber juniors should use the latest software on judicial analytics. The title of that software is Know Your Judge, to analyze and predict the way the new judge before whom I have yet to appear in my outstation appearance would rule. Before I can stammer out my bewilderment, remember this is 2040, he launches into a description of how this software has a 95% accurate predictive rate and covers a very wide range of subjects of all kinds in law. Before I can tell him that I normally like to sit physically in a new court before a new judge for a few minutes to watch the psychological thinking process of that new judge, he adds for good measure that his firm has now adapted and updated that software and customized it for the entire High Court, for each judge of that High Court, with individual judicial making and personal data, including all cases decided across subjects, so that its predictive accuracy as to how the judge will act and rule has increased from 95 to 97%. Before I ask my next bemused question, well, then why do you need senior counsel at all? And why bear my outstation fees? The two foreign-looking persons who I thought were also from this client team decide to chip in. The first says, "Oh sir, did not this young lady lawyer from the firm tell you that though this is an outstation case in an outstation high court, it does not involve your outstation fees?" As my astonishment increases, they say that now we have advanced, not normal, video conferencing in almost every court. So first thing is I don't need to travel physically at all. She adds impishly that my arguments are automatically recorded and accurately transcribed and reconfigured in text at the other end simultaneously. The last person in the room, a 35-year-old sober-looking man, helpfully adds that on my video conferencing screen, through which I'll do this outstation matter, there is a 50% chance that I will see a robot with twinkling eyes listening to me at the other end. And only a 50% chance that a human judge will be sitting at the other end or will come and sit for part of the time from his chamber and take a seat along with his robotic colleague. This second foreigner further condescendingly explains to me, as one would to an 80-year-old man who knew nothing of what the entire world was cognizant of, that the Williamsburg, USA smart courtroom model, which some of us have seen, established as a single model courtroom over 60 years ago prior to 2040, is old hat, and much smarter, much more automated robotic courtrooms have been replicated across the world through several pilot projects, including in India. He adds that as I finish arguing the case, the robot would be giving the judge the 3 best alternative draft verdicts on the basis of the argument, which would be the most appropriate for the law and for the justice of the case. He expects the robot to do it within 15 to 20 minutes of my finishing my arguments. Reeling with shock, and before I could tell my clerk to reconfigure my outstation fees, this man adds, "Oh, by the way, sir, what do you think are our chances of success in this case?" So as I blurt out, "You should know better through your Bloomberg Law Litigation Analytics software and its counterpart called Predictitis, which you use in your branch office in various countries, as also through your other software called Premonition Legal Analytics and Docket Navigator." He says calmly, he says, "Sir, I am neither the lawyer nor the client. This lady here is the client, and this fairly expensive litigation has been crowdfunded and crowdsourced through one of the first Indian startups called Avoca 8, which started 20 years ago and has now grown into the biggest entity in this field." Remember, we are in 2040. He also points out that under the new Crowdfunding Dispute Risk Act, passed by Parliament a few years earlier, which also seemed to have escaped my doddering attention, not only had all common law restraints on champerty and contingency fees been abolished, but that the recent Finance Act had provided tax incentives to encourage such buying, selling, trading in and funding of litigation. As I look helplessly at my wrinkled hands, this man goes on, "Sir, I am actually from the insurance company, and it is mandatory for me to be present at the conference with senior counsel. It is also mandatory for me to ask you as to your risk assessment amidst all this sea of automation, because I have to file a detailed report to my superiors, because we are the ultimate ones who have subrogated rights to this litigation. We also now have a growing financial portfolio of such litigation rights, especially in the areas of patent law, entertainment law and telecom law. But we are thinking of selling and transferring our telecom risk insurance portfolio to another entity, and will be coming to you in the near future for an opinion on this subject." A fractional degree of reassurance regarding the validity of my self-worth returns to me, some color to my face, and my 80-year-old slow-working brain rewinds to a hot, sultry afternoon in 1992 in a district court in Gurgaon. This is an actual incident with me. There, as a younger lawyer, I had appeared in a fiercely contested case against another senior counsel from Delhi, a very well-known senior counsel who is now relocated. Since I had subsequently written an article on it, the scene magically and vividly revived in my mind's eye. There was no air conditioner in that Gurgaon court. Both counsel argued while sweating profusely. My adversary briefly fainted from the heat, had to be revived with cold water, and two steel almirahs behind the lady judge had moth-eaten files falling out of the almirah, with many other files lying on top of the almirah. The Haldar shouted out the next case. A noisy typewriter belted out the evidence in chief of a litigant, simultaneously of course, and simultaneously the lady judge, very manfully, heard our rival arguments. 4 rickety chairs with broken plastic, lattice work, and a loudly whirring fan with dust piled on top of it, which threatened to fall on our heads, completed this antiquated picture. As lawyers, clients, insurance people, subrogators, and interns spoke on that 2040 evening, I thought, 1. The great saving of cost and time for the ordinary litigant who could now simply buy a software for most ordinary legal advice and save even lawyer consulting fees. 2. The saving of travel time, judge time, and lawyer time, and of course the diminution of all our outstation fees by video conferencing, voice recognition software, and the automatic storage of detailed arguments in text. 3. The increase in accuracy of judging by not missing any precedent and by producing 3 alternative templates of best solutions for the judge within minutes. 4. The unemployment generated by robos working not only as paralegals but as courtmasters, clerks, and interns. 5. The long pre-litigation journey to find funders for proposed litigation, either through crowdfunding or through crowdsourcing, as also the hunting of the most or for the most efficient insurance policy in that regard. 6. The role of senior counsel as stationary experts evaluating written submissions, written briefs, and giving somewhat superfluous predictive opinions with a wizened air instead of being rocket-like perambulatory machines running from court to court on Mondays and Fridays. 7. The exponential growth in legal process outsourcing used not only by individual litigants and companies but also by law firms to decrease costs. 8. The huge technically successful management of hundreds of case law precedents, but possibly and sadly the missing elusive compassion of the judge, the feel of the competent senior counsel, the individuation of the justice of the case. 9. The strange scene of litigants on both sides being insurance companies or buyers, sellers, and traders of litigation, with stock exchanges dealing with litigation shares of litigation-based companies and their related insurance counterparts, and with their prices of these shares moving jerkily each day. By the way, such jerkiness in share prices will be directly linked to the comments, complimentary or adverse, of the judge or the robo on a particular day. 10th, law schools and classrooms like those at Jindal would teach whole semesters and give only 50% credit for substantive law, and 50% weightage would be given for computer technology expertise, robotics management, financial insurance, subrogation management of litigation, dispute resolution courses. That evening in 2040, after a similar seminar organized by Jindal and an older Rajkumar on innovations in dispute resolution, where discussions were focusing on how to minimize both the number of judges and lawyers as managers of machines and software, and how to go from paperless to humanless offices, courtrooms, and methods of adjudication, I attended a reception in the evening. As I walked up to another octogenarian senior counsel standing with his wife, I passed on the way our 2 respective grandsons talking to each other and could not but help overhear them. That eavesdropped conversation of the 2 grandsons, which I illegally conveyed to the other senior counsel, was, "There go our grandfathers." Is it not astonishing how little they know of how dispute resolution is technologically conducted? Wonder how they were ever successful litigators. Well, friends, before I say goodbye and see you in 2040, let me add a few words of caution. This is the serious part of the whole. I was beating around the bush till now. One of the foremost challenges of this whole thing is the issue of accountability. Artificial intelligence systems, especially those powered by machine learning, often operate as black boxes. This opacity raises concerns when AI is used in legal decision making, such as sentencing or bail determinations. And this is going to be first and foremost used in these areas in the near future. If an AI system makes a recommendation, who is to be held accountable if that recommendation is flawed or biased? The lack of transparency in AI's decision-making processes can undermine trust in the legal system, necessitating the development of standards for explainability and accountability. Friends, another serious concern, a critical concern in AI is bias. AI systems ultimately learn from data, and the data used to train these systems reflect existing societal biases. The AI is likely to perpetuate these biases. For example, AI tools used in criminal justice have been found to disproportionately affect marginalized communities. There are some statistical surveys on this subject which have been published. Of course, the sample size is still small or moderate. Addressing this challenge requires a rigorous scrutiny of the data used to train AI systems, that is the primary data behind the data, and the development of algorithms that can detect and mitigate bias, or at least try and minimize. The challenge of regulation is also significant. The rapid pace of AI development often outstrips the ability of legal frameworks to keep up. This lag can result in a regulatory vacuum where AI operates without clear guidelines, leading to potential misuse. Developing adaptive, forward-thinking regulations that can evolve alongside AI technology is essential to ensure that AI is used ethically and responsibly. Moreover, the integration in law raises questions about the future of legal professionals. Obviously, AI cannot and should not even attempt to replace lawyers. While AI can automate routine tasks, it cannot replicate the nuanced judgment and the ethical considerations that human lawyers and judges bring to the table. AI must remain an efficient and obedient servant and never be allowed to become the master. It should always be viewed as a tool that can augment human capabilities, allowing legal professionals to focus on more complex and strategic aspects of their work. Friends, in conclusion, while AI presents significant challenges to the legal field, these challenges are not insurmountable, and they must be met so as to absorb, integrate, and introduce AI into our system by fostering transparency, addressing bias, implementing robust regulations, and viewing AI as a complementary tool rather than as a replacement. We can harness the humongous potential of AI to advance justice. The key lies in a thoughtful and ethical approach to AI's integration into law, ensuring that this powerful technology serves the greater good. Thank you very much indeed, and see you all in 2040.
Thank you so much, Dr. Singhvi, for those insightful perspectives.